Namaste, friends, and welcome to the Saturday edition of Words of Wisdom, Gyan Ganga, which we call it the legal words of wisdom, Nyay Gyan Ganga. Today is the 21st episode where we have been at Virat Hindustan Sangam trying to educate the people on the rights and on the various legal aspects and educate them on question of law. As you know, we discuss various topics, and virtually we have come to the end of our series. And today, the Indian legal system, can it be saved from collapse, is the topic we have been discussing. We have been very grateful and thankful to Dr. Venkat Iyer, who has taken the trouble of putting this 21 episodes together, and the viewers and members of the Virat Hindustan Sangam have thoroughly enjoyed this education they have got on the law series. And we also thank Dr. Subramanian Swamy for his daily or weekly inputs in this program. So as we have mentioned, the topic today is the Indian legal system, can it be saved from collapse? And Dr. Venkat Iyer, as you all know, is based in the UK, and he is a barrister, mediator, and does lot of legal academic work across the globe. Or is originally advocate in the Bombay Bar, and then after he migrated to the UK, and we have this with him. We have this program with him on every Saturday, and today we will be discussing about our collapse of our legal system and how it can be salvaged. Anybody who uses the Indian legal system or values it will be concerned about the poor state in which it finds itself today. There are huge delays in the handling of cases and the escalating costs which make justice unaffordable to the common man. This is a particular worry against the claims of the government that India would soon become a $5 trillion economy and an economic superpower. What are the causes of the problem? Can the shortcomings of the legal system be rectified? What are the reforms needed? How quickly can they be implemented? Will the system ever become fit for purpose? These are some of the issues that will be discussed in this episode. After 20 previous episodes where we had various aspects of the law discussed in detail, today we come to this thing of our entire legal system, how effective it is, what are the shortcomings. So with this, it is over to Dr. Swamy for his introductory remarks, and then Dr. Venkat Iyer will take us through the whole system and how it has collapsed and how it can be revived. I thank my co-host Ramesh Swamy for his inputs and putting this program together. I also thank our technical team led by Ashish Shetty, Vishal Mehta, Tejas from Pune, Ramesh Iyer from Navi Mumbai, Swaminathan from Chennai, and Rakesh Gadgi from Karnataka for their daily and weekly help to put the program together, and thank them all for their support we have received for the 21 episodes. On Sunday, we have a regular Gyan Ganga, and we are racing towards the 100th episode very soon. I think we have reached 97, and we have 3 more episodes to make it into the 100th episode, independent of the Saturday program. And we would request you also to keep watching this space. From next Saturday, we will be probably starting the economic words of wisdom, or Arthik Gyan Ganga, as we will be calling it. And Dr. Swamy will, with Dr. Arvind Chaturvedi, will be educating our viewers on the economic situation or basics of economics for the benefit of our viewers across the globe. So with this, it is over to Dr. Swamy for his introductory remarks.
Yep. Well, I mean, I'm also looking forward to hearing Venkat, because he's got a razor sharp mind, and he has been, as he's been demonstrating in all these past sessions, how well he has dissected the legal system and explained what it meant. Now, on the overall picture, well, it's easy to find fault with the judicial system. Actually, it's got nothing to do with judicial system. First of all, there are not enough judges. And the reason is that the procedure is unduly delayed at the government level. It's also delayed at so in the Supreme Court level because of this collegium they have, the collegium system, which when I was law minister, for example, I only had consulted the Chief Justice, but I made the choice myself. And then it was misused in the succeeding Narasimha Rao government by the then law minister. And so the judges in a rage, had a PIL, which they must have instituted themselves, and decided that judges selection will be decided by a collegium of judges, and that recommendation will go to government, and government, if has any objections, can convey that, and then ultimately the president would swear in that person. So therefore the system has undergone change and there's been delay, and the number of as the faith in the judiciary grows, the number of cases also grows. After the 2G, I've been flooded with requests. I take up this, I take up that, and so on. So and in therefore we need a much larger bench than we have both in the High Court and the Supreme Court, and of course much better facilities. Of course, there are a number of examples of where facilities have been excellent. For example, the Saket branch of the District Court in Delhi is about as modern as you find them in the United States, and as clean also. And so the changes are taking place. So I would say, in short, need more judges, increase the retirement age. Presently, High Court judges retire at 62, and Supreme Court judges retire at 65. I would say let them retire at 70 to begin with, and then of course the High Court judges at 65 because we have shortage. Or all those judges who retire in the High Court and the Supreme Court, they should form the government should create a constitutional amendment by which they can form a consortium where judges, the Supreme Court feels that something is very mundane and shouldn't be taking the time of the Supreme Court, they can refer it to that judges. So all the retired Chief Justices, judges, there will be members of that, and they can dispose of cases which are very, very, very ordinary and takes our time consuming, and not anything got to do with fundamental rights or some major change in the law, that sort of thing. So I would say that. And finally, we have some mechanisms which these lawyers are objecting to, and that is what the Americans practice. The Americans practice a system called discovery and interrogatories, where you don't reach the trial stage till privately the two parties sit and exchange. The interrogatory means I can file a series of questions saying, I believe you went to Timbuktu in such and such year. Can you please give me a photostat of the copy of your passport where it shows when you went there and when you left? That kind of thing. And discovery is that that there is a document in your opponent's hand, whoever is opposing you in the case, and you can then file an application to him and say that please give me a copy of that, and in an affidavit. So by the time they go to the trial, all this question of documents, this thing, adjournments, everything goes. And that's why in the United States, the trial level, it goes very fast. And in Supreme Court, I'm not asking that we replicate that. In Supreme Court, all the judges sit together, 18 of them, I think. They all sit together. The plaintiff comes and he speaks for 20 minutes. And then the defendant speaks for another 20 minutes. And then a reply is given by the plaintiff for 10 minutes. And then the entire court gets up and goes into their chamber. And then after some time they come back and then they announce the judgment there and then. Now, in the meantime, of course, all the papers, this, that, everything is already been filed, and they have studied it. So that's a very fast way. I don't think at the moment in India we are ready for that. But I would certainly say that the kinds of emoluments post retirement for judges and all should be such that they should not even look for and hope for any governmental commissions or National Human Rights Commission chairmanships and so on. So those are the things I would say very quickly. And now over to Venkat to give us his words of wisdom. Gyan Ganga. And we enjoyed all your presence this time. Sorry that we are going to miss you, but then we know how busy you are and how much time you are devoted. So in advance, I thank you on behalf of all of us and the audience that you have done a wonderful job.
Thank you, Swamy. I'll reserve my thanks to the end of this talk. Now, one of the questions that I've been frequently asked, both by viewers of this program and more widely by audiences whom I've addressed in India and abroad over the years, is can anything be done to make the Indian legal system fit for purpose? This is a subject which is quite painful to talk about. It is also a subject which, for a comprehensive analysis, will need much more time than is available to me today. But I still thought it is worth discussing, given its practical importance to anyone who values justice and who believes in the rule of law. So I plan to offer my views on this topic in what will be, as you have pointed out already, my last contribution to the current series on legal words of wisdom. Most people, I assume, agree that the Indian legal system as it stands is not fit for purpose, that it does not always deliver justice speedily, efficiently, effectively, even-handedly, free of corruption, and at a cost that ordinary people can afford. There is also widespread agreement that the situation has got progressively worse over the years. And this is reflected not only in the statistics about increasing backlog of cases waiting to be heard in the courts up and down the country, but also by people's direct experience of the user unfriendliness of the system. If you want a chilling statistic, here it is. There are at least 40 million cases pending in the various courts of India. And that number has been growing by, I'm told, at least 6.5% per year. If you're not shocked by these figures, consider this. From time to time, various senior judges have calculated that even if no new cases are filed from any given date in recent years, which of course is an impossibility, it will take the system as it stands around 360 years to clear the backlog. In the immortal words of that great visionary, Nani Palkhiwala, a lawsuit once started in India is the nearest thing to eternal life ever seen on this earth. In quite a literal way, cases are handed down from one generation to another, giving that phrase intergenerational litigation a very poignant meaning. Now, what has caused this state of affairs? The reasons are as varied as they are complex. The views that I'm about to offer, of course, subjective, and I freely concede that they may not command universal acceptance. But I hope you will give them some consideration. I'm often appalled by the complacency with which Indian officials, politicians, and judges treat this subject. It is almost as if the problem is just an innocuous one, which can be solved either with some platitudes or with some minor tinkering around the edges. Little do they realize the long-term ramifications of it. Before I look at the structural and other issues, I want to say that the legal system is as much a victim of the collapse of ethical values as are other institutions in contemporary India, which means that no matter what changes you may make to the law or to the architecture of their justice administration framework, those changes are unlikely to bring about the desired improvements unless enough attention is paid to the people operating the system at various levels. And that is going to be a monumental task, much more difficult than fixing the laws or the architecture of the system. The first thing I would say in relation to the human factor is that for at least 5 decades now, India has got increasingly cut off from the rest of the world in many significant ways. From the 1960s to the early 1990s, the self isolation of India from the rest of the world was near total. I'm referring in particular to the locust years of Indira Gandhi's rule, during which India, in effect, retreated into a shell. And this had profound effects in the legal arena because a whole new generation of lawyers grew up without any exposure to the outside world. As a result, there was a huge estrangement between Indian lawyers and their global counterparts, which was reflected even in such matters as the language and the idiom employed by the Indian legal profession, which most foreign lawyers find very difficult to understand. Even today, when Indian lawyers attend international conferences in various parts of the world, not just in the West, but also in other Asian countries or in Africa, it is embarrassing to see them being unintelligible to their counterparts abroad. A sadder part of the story is that there is hardly any concern within the country that there is so much estrangement. This was not the case before the 1960s, when Indian lawyers were able to communicate well and mix with foreign lawyers as their intellectual equals. Indeed, the Indian legal profession enjoyed a huge amount of respect abroad at that time, and Indian law was seen as a gold standard by many Asian and African countries.
Right.
Part of the problem is that the quality of formal education, including legal education, has fallen sharply over the past few decades, with the result that even basic communication skills of those joining the legal profession have become substandard. This is a decline across the board, and nothing is being done about it. You only have to read the judgments that come out of the courts across India at all levels of the judicial hierarchy to realize how lamentable the situation is. And sloppiness in language inevitably has an effect on sloppiness of thought. It could also, of course, be argued the other way around. I would say that a starting point for the woes of the Indian legal system is the education and training of lawyers. In simple terms, there are far too many law schools, many, if not most of them, of unacceptable quality. And these churn out far too many law graduates without giving them the grounding that those who want to practice as lawyers need. And this criticism applies to both the public and private sectors, including the various national law schools established in the past couple of decades. I'll say without hesitation, and at the risk of inviting unpopularity, that there is today not a single law school in India which can be called world class. And I'm not comparing them to elite institutions in the West, just to good universities in other parts of Asia. I freely concede that some of the students coming out of a few of the Indian law schools are bright, but I would argue that they are so not because of their universities, but in spite of them. The pursuit of a rounded education, which allows the student to think, to reason, to compare, to discriminate, and to analyze, in the words of John Henry Newman, has been all but abandoned in favor of commercial gain and other baser goals. If the quality of education is bad, the situation concerning practical training of lawyers is worse. For several decades now, there's been no system of practical training. Let me explain. In almost every country in the world, regardless of the nature of the legal system, anyone who aspires to practice law has to go through at least 2 years of training after they have graduated from law school. They also have to pass a series of exams to qualify as a lawyer, which are in addition to the exams that they may have taken at law school. And in countries which care for quality assurance, a student who wishes to proceed to the stage of professional training needs to achieve a certain minimum standard of excellence in his law degree, unlike in India, where even those with a third class degree obtained after part time studies using substandard textbooks is allowed to enter the legal profession. I know that I'll be accused of elitism when I argue for tougher standards, but my answer to that charge is you do need strong quality control when it comes to admitting people to any profession where they will be serving the public. Just imagine if you allow an ill-qualified person with poor academic credentials and no training to practice as a surgeon or an architect, what the consequences would be for society. It should be no different for lawyers. I'm all for supporting students from disadvantaged backgrounds, but that support should start at school level and enable the disadvantaged student through sumptuous scholarships to attain the same intellectual and other qualities that someone from a more privileged background manages to attain. That way, the student himself will feel that he has qualified as a lawyer on his own merit and not as a result of some misguided affirmative action program. I accept that such fundamental change in approach to supporting weaker students will take time, probably a generation or two, but the wait is, in the long run, worth it. What is needed in practical terms is a tough bar exam, followed by at least a year's genuine apprenticeship. This will incidentally bring down the number of lawyers eventually qualifying to practice, which I would argue is a good thing for society as a whole. Those students who fall by the wayside because they have not been able to pass the tough exams or complete their apprenticeship should be allowed to pursue alternative careers as paralegals, of which there is a huge need in a country like India. Some people can help in minor drafting or providing logistical support to those needing to use the law, especially in the villages and small towns. The other very important reform that needs to be introduced is that legal practice should be subject to a strict regime of annual licensing. This is what happens in most countries. Indeed, if you were to tell a lawyer in New York or Tokyo or even most of Africa that you can practice law, as everyone does in India, without an annual practicing certificate, they will laugh at you. Such a certificate has many advantages. More than anything else, it signifies a seriousness on the part of the practitioner and it keeps him on his toes. It also allows the Bar Council or other regulator to know who is in practice and who is not. Today, you have the absurd situation in India where the Bar Council wouldn't know if a practicing lawyer has retired or even died unless someone informs it, with the result that the rolls maintained by the Bar Council can never be up to date. In all decent countries, there's also a need for lawyers to obtain professional indemnity insurance every year to ensure that clients who become victims of the lawyer's negligence are able to be compensated. And the lawyer is protected as well if a claim is brought against him. In addition, many countries have a requirement for continuing professional development, under which every lawyer has to show that he has undertaken a certain volume of studies or other learning to keep his knowledge updated. This then brings me to the next important reform that is needed. The regulation of lawyers needs to be strengthened. The system that exists today is a cruel joke. The bar councils are hotbeds of politics, manned by, I would say, semi-literate people whose adherence to professional ethics is in many cases highly doubtful. Unless you have tough, even-handed and efficient mechanisms for the regulation of lawyers and a complaint system which users of the legal system can have trust in, you will have crooked lawyers fleecing their clients with impunity. So, one long-term reform which cannot be avoided, but which will not be easy to implement, is for a thorough cleanup of what passes for the legal profession in India. The number of so-called lawyers will have to be brought down drastically. Tougher entry requirements will have to be introduced for many, or actually for all new lawyers. And I would say that many of the existing law colleges will have to be closed down and the regulatory system completely overhauled. Even with the best will in the world, and I cannot see that will existing at present, the process is likely to take up at least a couple of decades, but it cannot be shirked. Next, we come to the judiciary. I have in my previous talks frequently underlined the importance of an incorrupt, efficient, independent, and competent judiciary for the survival of the rule of law. You may not be able to appreciate how important such an institution is until you begin to imagine the consequences of its absence. In the ultimate analysis, any dispute, however large or small, will end up in the courts if other mechanisms for its resolution fail. And if you have a judiciary that does not do its job properly, there is no hope at all, unless you believe in resorting to vigilante methods of resolving disputes. And where do judges come from? For the most part, they come from the pool of practicing lawyers. So if you have substandard lawyers, you're not going to get good judges. In India, the problem is compounded by the fact that historically, the salaries of judges have been shockingly low, which means that many talented and successful lawyers are unwilling to become judges. I accept that in any country there is a disparity between the earnings of practicing lawyers and judges, but the gap is intolerable in India. In India, it's a scandalously wide chasm, actually. I'm not exaggerating when I say that there are many lawyers who make, and I deliberately use the word make rather than earn, more money per day than what the senior most judge in the country earns in a year. How can that possibly help in recruiting talented people to become judges? Poor salaries also translate into invitations to corruption. And who can deny that judicial corruption has become quite alarming in its scale at all levels of the hierarchy? The combination of lack of integrity and lack of competence is a poison that is proving extremely toxic and which has a potential, if it is allowed to go unchecked, to destroy the system irreversibly. Now, concerning the lack of competence, I'm truly appalled at both the extent to which this problem has spread within the judiciary, including shockingly right up to the top of the judicial pyramid, and the depth of ignorance and ineptitude shown by most judges. Today, it has become impossible, and I really mean it, to read most judgments or orders without either scratching one's head about what the judge is trying to say or flinching in horror at the inability of those writing them to even string a simple sentence together. And we are not even talking about the kind of show of style that the likes of Krishna Iyer used to adopt. Moving on to other ills plaguing the system, one thing which should strike any reasonable observer is the sheer scale of misuse or even abuse to which the courts are subjected. I agree that in a large country like India, there will be a huge amount of litigation. But what one sees is a disproportionate amount of avoidable litigation. And there are many reasons for that. For a start, the other branches of the government don't do their jobs properly. You have legislative bodies passing what I can only call half-baked laws, which require judicial interpretation, or executive authorities treating citizens with disdain, indifference, arbitrariness, contempt, all of which eventually end up clogging the courts. I'm reminded of a poem that I learned in my youth, the first lines of which went like this. I'm the parliamentary draftsman, I compose the country's laws, and of half the litigation, I am undoubtedly the cause. A particular villain in this is the government itself. A lot of cases are filed by state agencies mindlessly, and a lot of the time civil servants and officers of public sector organizations file appeals in hopeless cases, knowing full well that those appeals will not succeed but seeking to hide behind the judiciary for conceding, in effect, that they were wrong in the first place. I would argue that if unnecessary government generated litigation is stopped, the effect on judicial arrears will be dramatic. A second problem is that the courts themselves, through either inefficiency or misguided policy initiatives, create a litigation explosion which they cannot then control. A striking example of this is called public interest litigation, about which I've spoken previously. Much of what passes for PIL in India has no public interest at all, but it keeps everyone happy at the cost of public weal. The time has surely come, however belatedly, to call a halt to the circus that currently passes off as PIL at both the High Court and Supreme Court levels. This, in turn, will take away another substantial chunk of pending cases. I suspect Swamy may have a slightly different view, and I'm very happy to hear it later on in the discussion. One cannot, in all this, ignore the dishonorable role that is played by private sector lawyers in fomenting or encouraging litigation. There are many situations in which more responsible and less selfish advice by lawyers to their own clients will not only help in solving the crisis of backlogs in the courts, but will also save the clients themselves a lot of money and trouble. But in a system which encourages dishonesty and ignoble behavior, lawyers have a lot to gain by behaving unprofessionally. Having said all that, is there any hope for redemption? In the short term, there are at least two steps that I can suggest, which I think have the potential to ameliorate the situation to a significant extent and fairly quickly. But they require massive determination and tremendous political will to implement. The first step will be for courts at all levels to start imposing costs on unsuccessful litigants. There's nothing revolutionary about this measure. It is followed in all countries that believe in the rule of law and in the fair administration of justice. What it means is that if someone were to bring a case against someone else and lose that case, the losing party will have to reimburse the winning party all reasonable costs incurred by it, that is, by the winning party. The Indian courts should also start enforcing their power to award exemplary and punitive costs against litigants whose conduct in litigation is blameworthy. For example, where a party brings a case in bad faith or adopts a vindictive attitude in litigation. By doing this, the courts will begin to send out a signal that litigation should not be resorted to lightly or frivolously or vexatiously. People should be made to think many times before approaching a court, which they hardly do at present. The second major step which should be adopted simultaneously with the imposition of costs is to make mediation compulsory in most civil litigation. No party, except in certain unavoidable circumstances, should be allowed to use court processes without first engaging in good faith mediation efforts. The good faith part is important. I'm of the view that there are very few countries in the world where mediation has been crying out to be used on a large scale than in India, and very few countries where it is shunned as strongly as it is in India. Lawyers are quite happy to encourage arbitration, but not mediation. The reason is that arbitration in effect ends up generating more work and therefore more money for a lawyer, given the multiplicity and the complexity of proceedings, which mediation does not. Besides, mediation can be attempted by non-lawyers quite easily. In some cases, actually, I would say that the involvement of a lawyer in a mediation exercise is positively unhelpful. And what is more, Indian culture has a glorious tradition of the use of mediation, especially through the involvement of respected elders in society in various types of disputes. And that tradition can and should be tapped to everyone's advantage. But I can assure you that both the above steps will be vehemently resisted by various lobbies, starting with lawyers. And don't underestimate the power of these lobbies. In a country like India, many of these lobbies also have unholy alliances with politicians, with the result that all manner of roadblocks will be put in the way of decisive action. The cooperation of judges will also be needed in implementing these reforms, and there is no guarantee that such cooperation will be forthcoming. If you see the current state of judicial leadership, you'll begin to wonder if there's any hope at all of either the desire or the necessary capacity for change. There is no dearth of pontifications and preachings from various pulpits, but of genuine and decisive action, there is very little evidence. Interestingly, you'll hear many politicians talk airily about India becoming an economic superpower soon and a $5 trillion economy even sooner. But have the same politicians stopped to consider how important a clean, efficient, and competent judiciary is to achieve those goals? I've pointed out several times before what a dismal position India enjoys in the league table for the enforcement of contracts. If that doesn't change, the country, I would say, can kiss goodbye to any hopes of making its way in the world. So one of the drivers for legal reform would have to be pressure exerted from outside. Internally as well, unless the ordinary citizen is assured of access to justice in a way that is consistent with an open society and the rule of law, the potential for conflict and lawlessness will only increase, and that cannot be a good thing. Once people begin to lose faith in the judicial system, the consequences can be catastrophic. In the case of India, it will be particularly tragic if that comes to pass, because India is a country not only with a glorious heritage and a proud civilization, but also one where there is no dearth of talent. I've tried to present an overview of the depressing situation that the law and justice sector in India finds itself currently. What I've said, of course, is far from comprehensive or detailed. I haven't, for example, covered what reforms need to be introduced to the system of court procedures or case management or better use of IT, etc. But I hope I've given you some food for thought on this extremely important topic. Many of you have been asking questions about how the broken legal system can be fixed. All I would say in conclusion is that the youth of India should start picking up the gauntlet and demand change, disregarding the usual smokescreens that are erected by vested interests in favor of maintaining the status quo. To do that, you should be fully educated on the relevant issues and arguments that you are able to deal with and deal effectively against any misleading or extraneous points that are put to you. You need to have the big picture firmly and always in your mind. Don't get obsessed with trivia. So this brings me to the end of the present series of talks in the Legal Words of Wisdom series. I've thoroughly enjoyed doing these talks for what is now 5 full months. When Jagdish first raised the possibility of starting the series, I had in my mind a more modest aim of doing, say, 10 episodes. But given the interest that you, the viewers, have shown in what to many people is a dry and boring subject, I was sufficiently enthused to stretch it to 21 episodes. I want to thank all of you for your support to the series. I also want to thank the people behind the enterprise, starting with my 3 constant weekly companions, Ramesh, Jagdish, and Swamy. And who can forget the technical team, Ashish, Rakesh, Swaminathan, Ishwar, Tejas, and Vishal. I hope I've got everyone's name there. Only one of whom, incidentally, I've actually met. In closing, I do hope that the interest of you, the viewers, in law and legal matters will continue, and that with some luck, VHS will one day, as soon as the pandemic is firmly behind us, organize some sort of a conference where we can all meet in person for much longer discussions on these issues. In the meantime, like most of you, I'll be watching the new series, which will replace this from next Saturday. Thank you very much.
Thank you, Venkat.
Go ahead.
Yeah, I mean, personally, from my end, I mean, I learned a lot. Your calm, manner in which you pass, but very strong views, is a change. Instead of no histrionics, no jumping around in typical way. So I mean, we've learned a lot from Dr. Swamy. Now we've learned a lot through you. It is amazing what we have learned so far. I mean, I enjoyed preparing for the show. I mean, every week when you send the email, I have to go put out those slides, and I enjoyed doing it. So basically, it got me involved in the entire technical team. They enjoyed whatever you gave us all along. So personal thanks from my end too. Oh, go ahead, Dr. Swamy.
Well, I mean, I've already said what I wanted to say in the very beginning, but I would add one thing. That law is like the old days, and the warriors were taught how to use weapons. You see, so every citizen must be exposed to a minimum knowledge of law. So he's not bamboozled, he's not scared, he's not frightened, and so on. I find most people are frightened to go to courts. Most people are frightened if the policeman comes with an FIR to their house. They don't know their rights. And that is the essential problem that we have to overcome. And consequently, I would say that that if you are going to reach a situation where everybody knows some law, I mean, the basics, everybody knows. He knows what is CRPC, he knows what's IPC, he knows what the Civil Procedure Code is, in the broad outline. Then he becomes a strong person. He can't be pushed around, and you can't have somebody come and some fat lawyer come and threaten people. So that, I think, this fear of law should be removed. And familiarity with law should be there. And therefore, I would say probably from class 10, we should have at least some one course on the legal system and what the laws are. What's the difference between the laws passed by Parliament and the Constitution of India? What's the difference between constitutional rights and legal rights? So all these broad concepts should be a part of the compulsory teaching in school. And I think the mere fact that our series has gone so well, of course, much of the credit goes to the thorough preparation of Venkat. But I've seen people who have been extremely happy that they have been initiated into this legalistic thinking. And I think, therefore, the country would benefit if this all came into the school system.
So, Venkat, I'd like to take a few questions that we got, so we can just go from there. Recently, there was in the UK court, I think Kaju and one other judge, they were criticized in the courts. So, Dr. Swamy, first your thoughts, and then Venkat, and saying, I mean, is this an extension of what you just mentioned today? I mean, the lack of global, outlook. I mean, the lawyers are even so-called famous lawyers are so ill-informed as to how to, put themselves out in a global world.
Well, I mean, Kaju is a very fine lawyer, was a very fine judge. His judgments have been extremely good. And some of it, for example, when he brought in the Sanskrit principles of argumentation, Mimamsa it was called. I think, he is a very learned man, but obviously he is a bit opinionated according to some. And I think the intrusion in the case in London was not well received. So there's nothing more I can say about it, because the English court need not have reacted the way they did. Well, Venkat is from that area. Please tell us what you think of did you read the comments that they made, the judges made?
I did, with a sinking heart. So, well, let me say this. I agree with 2 points that Swamy just made. Actually, sorry, I agree with 1 point that Swamy made, and I'll make one supplementary point along the same lines, which is that Kaju is a man of some learning when it comes to Hindu philosophy or Indian philosophy for that matter. I would add to that he's actually also very good at Urdu. But beyond that, I don't want to say anything because it'll take away from everything that I've said so far, except to say that again, I have to unfortunately disagree with Swamy, and I would say that the comments of the magistrate in London were entirely justified because, quite frankly, Kaju made an ass of himself. Unlike the other fellow, Tipsey, who also gave evidence that was rejected, but not doing it in the way that Kaju did. Now, I don't think it's good enough to say, but that's his habit. If that's his habit, let him keep it within India. This actually creates such a bad impression about Indians in general and Indian judges in particular. And this man was actually a judge of the Supreme Court of India. Even a magistrate from any Commonwealth jurisdiction would not have behaved as disgracefully as he behaved. Now, it is true that when someone comes to give expert evidence, which is what Kaju and Tipsey did, they will do everything possible to defend the interests of the people who hired them. And remember, they're all hired, they're paid huge amounts to give evidence in these kinds of cases. So they will do everything possible to protect the interests and to advance the interests. But you still have to have some ethical moorings, which you should not transcend. There was a similar attempt made about 20 odd years ago when we had the carbide litigation in India. This was against the Bhopal gas
Union
tragedy.
Carbide.
And what happened there was that a lot of lefties argued that India's legal system was so bad that there was no prospect of anybody getting justice, so the cases should be heard in America. Just imagine the irony of it. And it fell on the likes of Nani Palkhiwala to go and argue the opposite, to say that yes, the Indian legal system suffers from a number of deficiencies, but to condemn it as impossible of delivering justice is outrageous. So you have to have a sense of proportion, a sense of balance in all these things. Kaju just made an ass of himself. That's all I'll say.
Well, I just add that normally I'm not diplomatic, but this time I've chosen to be diplomatic. And so I won't say more.
Okay. So one other thing, there's another question that says, is there a way for common people to say, hey, how do I go find a good lawyer or not a good lawyer? So that's a very difficult thing to do, right? Unless it's you hear somebody refer you, right? Is that because it's very difficult that there's no there's no grading system saying that, is a grade A lawyer or a grade B lawyer. I mean, even doctors have some kind of a grading, but we don't have any in law profession.
Yeah. Well, I can offer two rough and ready rules, which are not scientific at all. The first is do not go by the popularity that a lawyer enjoys. It is usually inversely proportional to either his knowledge or his professionalism. And this is something which anybody who has used the system will tell you from personal experience. So if you find what I would call these glamorous star lawyers, then if I had a case, I would avoid them. Secondly, the only way you can try to get something like a good lawyer would be through word of mouth, through people whom you can trust. And I've actually been at the other end of the problem, in that increasingly over the last 20 years, people come to me and say, can you recommend an Indian lawyer? I've got a case in an Indian court. I've got an Indian legal problem. And it's not easy because people are mesmerized sometimes by big names. And I'm talking about people who can afford to pay. I'm not talking about ordinary people who cannot even think about approaching any of these star lawyers. And there I have to be careful and sometimes recommend people who may be very low key, but who are solid and who have very good ethical values. Really, to my mind, ethics now becomes even more important in India than legal knowledge.
Okay. Venkat, there's one other question for you. It says, in mediation, how do we encourage more mediation?
Very difficult to answer because mediation is consensual. Mediation cannot be compelled. The only circumstance under which there can be any element of compulsion is this. As I said earlier, if you make mediation mandatory in civil suits, then the judge can ask the parties at the start of the case, have you attempted mediation? And if the parties say we don't want to attempt mediation, then the judge can say, all right. The judge can't compel them to go to mediation. That is not possible. What the judge can do is he can say, all right, I'm willing to then proceed with the case, but do remember that if I come to a determination that a certain party has not made a good faith attempt to settle this case out of court, then I will impose severe cost sanctions on that party.
Okay.
Now that, of course, in most countries would concentrate the mind of a litigant, but I don't think it happens in India, partly because also Indian judges don't impose costs anyway. So there is that problem. But mediation is only possible if both parties genuinely want to settle a dispute. Now, a lot of the time in India, you have dishonest litigants because they know that they can take advantage of the system that allows them to drag a case on for 20 or 30 years. Why should they attempt mediation? Because if a genuine attempt at mediation succeeded, then the case would finish within a few months. So in those circumstances, mediation is difficult. But I still think that if a cost sanction was made quite tough, then mediation will begin to gain some traction.
Or can we
just leave me 1 minute, Ramesh.
No, sir.
See, mediation and discovery and interrogatory should be blend together. That is, you don't go to court to trial till all this exchange of documents, my plaint, and then my rejoinder, and then my counter reply. All these should be completed well before, and then the calling of witnesses to prove a document. All these should be done in a room in a court where you could have if because we have got a lot of surplus retired judges, you could have one of them sit in and guide them that this is the procedure and this is the way you go forward, so that by the time you go to the trial before the court, it goes straight to the trial, which is the American system.
So you're looking like a pre-trial process, right, Dr. Swamy?
Yes, that's right. That's right. See,
what Swamy is talking about is what we routinely call case management. So,
yes.
And case management is done not necessarily by the judge. Most of the time, it's done by an official called the master in most countries. And the master is like a senior registry official who knows or should know the law, and he is able to speed up the process that should happen before the trial. So that during the trial,
always mentions.
So case management, sadly, again, does not happen in India.
Yeah, it doesn't at all. Even the lawyers are against it. In fact, when I was law minister, I had raised this matter with the then Chief Justice, Raghunath Mishra. And I said, why not? This is already there in our Civil Procedure Code, by the way, both interrogatories and discovery.
Yep.
He said, you will have the lawyers go on strike.
Yep.
So I said, why? He says, because then they have to prepare. Here they just come and argue something. You see,
you can see whether
so you can take 200 cases one day. You see, the lawyers can take a large number of cases. 200 is exaggeration. A large number of cases, you can deal with 7, 8, 9. You see, and come and then take an adjournment. Then say, no, this document has not been supplied to me. That kind of thing. So he discouraged me. I would have done it, but our government didn't last long. So, but I would say that the discovery and interrogatories should be made apart, and there the mediation also should be dovetailed.
Yeah, because Dr. Swamy, you always mention that the US Supreme Court takes only so many cases a year.
Yes.
So much slot. You only have 20 minutes. That's it. You're done.
Yeah, you come and 20 minutes there, 20 minutes there in the other side, and then 10 minutes to reply. And then they all go inside the room and come back and deliver the judgment.
I mean, you have to provide the case document so clearly, like what you said, Venkat. Yeah. It has to be clear. You can't just throw books at the judges. You have to clearly say why. and core points are discussed, and only then that the judges ask, so why do you cite this case or that case law or this case law or something like that. It is fascinating, but I'm just saying the number of adjournments we see, even at the Supreme Court level. Supreme Court has literally become a magisterial court in India to a large extent. The number of cases that are coming to Supreme Court is just mind-boggling.
Yeah.
They just. Dr. Swamy, one comment I wanted to make, you mentioned in the start, you talked about retirement of judges. I mean, increase the retirement age, bring in retirement. That's a great thing because you're bringing in more quantity, but quality has to be addressed as well. Because one thing, this is more of my personal comment, because coming from Tamil Nadu, I have sadly, I think Venkat mentioned this earlier in the talk, was the so-called caste-based promotions to judges has really had an impact on the quality of judges that the courts have seen. Not maybe necessarily more so in Tamil Nadu, because I don't know about the other states.
No, now it's more difficult to do because of this collegiate system.
Okay.
Earlier on, as I told you, all the judges I appointed. All I did was tell the Chief Justice, "Do you have any objections?" He said, "No." Okay, I have sent it to the President. So that system is gone, and what you are suffering today is the last remnants of the system that was there when Karunanidhi first came to office.
Right. I mean, we saw a spate of these kind of judges that have pretty much destroyed, caste-based reservation. Hopefully that needs to be kicked out.
It's not like that. It's not like that. Very much like that anymore.
Even at the state and the magistrate level.
I appear in Madras High Court.
Okay.
And I've got always reliefs, and by and large, and it has nothing to do with the quality of the judge. Quality has been pretty good all through. Not any prejudice that I'm a Brahmin and the judge is a hater of Brahmins. That kind of thing we don't hear very much nowadays.
Okay.
Venkat, I have just a comment.
Yep.
Many of the courts, or maybe the small causes court, now virtually in Mumbai, compulsory asks for mediation.
Mm-hmm.
That they are doing it just as a formality.
Yep.
They say we'll send it to the mediation center, and after maybe a month or 15 days or 1 month or 2 months, they get a report that the mediation has failed. So not really serious attempts are made, but it is just one more formality to be completed, and it is referred for mediation.
Yep. So that is a major problem.
Yeah, that type of an attitude also doesn't take the seriousness of mediation too far.
No, it doesn't. Well, that's why I'm very careful to use the phrase good faith before the word mediation, because mediation as a formality is not going to help anybody. If anything, it will actually add to the delay, because there'll be that extra time completely wasted. But secondly, the way that can be dealt with is if you had a decisive, clever judge, a judge who is able to see through that facade and then to say, look, what you have done is not what I had in mind by way of mediation. Now let us see how many of these issues cannot be resolved without a full-blown trial. And it is possible. In fact, I know of a few judges in the Indian system, even the time when I used to practice, there were many of them who were capable of doing that. And I would still tip my hat to a particular judge called M.L. Pense in the Bombay High Court. He was a very low-key judge, not a man who was educated abroad, very sort of homegrown judge. But what a remarkable sense of justice he had, and of course completely incorruptible. And all he would do is to ask pertinent questions. But of course, he also came thoroughly prepared before the case came up before him. That is terribly important. So you need intelligence, you need preparation, you need the capacity for hard work, you need so many things. So this mediation thing is becoming a racket. And one of the reasons is that the dishonest litigant in India has no incentive to engage in good faith mediation, because he is going to win in practical terms by allowing the system to delay the case.
Yeah. There was one question. Are you through with that answer?
Yeah.
Okay.
Yep.
There was one question I just saw being scrolled, that why are the judges getting so much vacations, more than even school children? Well, they have to write judgments. And you know,
that is a red
they
herring
must
which has
have
been thrown about a lot.
Yeah.
There is no doubt that in the Indian situation, the whole idea of vacations is, in optical terms, quite bad. Why should the judiciary
Yeah.
be different from other public sector organizations? But I mean, it's possible decently to justify vacations, because a lot of the research that judges need to do
Yeah.
refresh themselves. Also, don't forget that the conscientious judges do a
Yes.
good job of writing their judgments, and writing a
Yes.
judgment is not easy. It's not always possible for a judge to dictate an order in court. Some of
That's
the
right.
judgments require a lot of preparation, and
Yes.
all that can be done during holidays. And finally, I would say that the duration of holidays has actually reduced dramatically. When I was in
Yeah.
practice in Bombay, the summer holidays used to be 2 months. Now I
Yes.
think it's no more than 5 weeks. And
Yes.
many of the other holidays have been either curtailed or done away with altogether. So there is a problem there, but it's not quite as bad as it is made out to be. If you had
Yep.
efficient judges, then no matter how many vacations there are, the justice system will still perform reasonably well.
Yeah, but the number of cases listed per day before a judge is obscene, in my opinion.
Yep.
So much.
Yep. Well, again, to do with case management.
Yeah, I agree. That's all that need. I would say even today, our judiciary is far superior to Pakistan's, Bangladesh's. So
Dr. Swamy, your aim should be to at a much higher level, right? We can't go keep
no,
on.
we are all the same people. Bangladeshis, Pakistanis, and so on. We were one country once upon a time, but we are still a democracy, however imperfect. We have a judiciary system which, by and large, still not every judge, but selectively they make a good name. We have judgments like Kesavanand Bharati case and the Minerva Mills case and the Bommai case and so on. They have really created a new awareness as to how many rights a citizen enjoys. So I would not be too harsh. And considering the schedules they do, I mean, I can't go to work after eating lunch. I must have a nap. The judges don't have any nap. It's just 1 hour lunch, and by the time they go meet, sit down and eat, and it's time to come back. So I think we have to look at the angle not so much as a start, because you have covered the whole picture. I'm saying start with the attraction of good judges. People really want to be judges.
So,
Yes.
One of the sensitive thing. But before that, Venkat, is there like a small claims court kind of a concept in India? I don't know. I'm just asking.
There is. Actually, that's what Jagdish was just referring to. Something called the small causes court in most metropolitan cities. Now, what I would imagine, because I've never practiced in a rural area in India, I would imagine that the small causes equivalent would be in the district courts. In other words, there would be probably a bench that deals with very small amounts.
Yeah, but the challenge in the US, even though if you go to a small claims court, the judgment is pretty much kind of final. I mean, appeals are very rare.
Yeah.
But in India, even if you go to small causes court, the appeals can go all the way back up to the Supreme Court.
Because we Indians have this prestige question, you see. Give and take is not a very present day Indians. I know that ancient Indians, the concept of Shastrats, you see, where you debate it and then you give and you take. You see, Adi Shankara had perfected this. So in India now everything has become a prestige issue.
In the Supreme Court of India, it is possible now for cases to be heard 3 times at 3 levels. So you have the case being heard for the first time, you have something called a review, and you have something outrageous called what is it called? I forget the name. Curative petition. Yeah. So just imagine at the Supreme Court level. So I think it is possible for a case to go through the court systems in India at least 7 times. which would be shocking in any other country.
One last sensitive comment, Dr. Swamy, you don't have to reply to this. A lot of the judiciary today are making their judgments to safeguard their post-retirement postings, right? So I'm also trying to do, walk this on a fine line. Yeah, that definitely has an impact to some extent, whether we agree or disagree on it, because a lot of these judges, instead of sitting there and say, okay, I've done a lot of good jobs, I can do a lot more. Instead of that, okay, now I'm just saying, what is my next? I need to keep my bungalow in Pandara Road or something like that.
That's what my mind.
No, I'm just saying, a lot of these things.
You must understand that judges are not made in heaven. It is a genuine problem. If you're a very honest judge, it is a very big letdown once you retire. And I know many of the retired judges, very honest. I go and meet them sometimes. There's no doubt that today the retirement age is indecent. 65, Supreme Court judge retires. And then today, 65, a man can be healthy at least till 80, at least. I know that Jethmalani used to argue till 94. Present Attorney General is 91, Venugopal. And,
but he's above the 70-year limit, right?
But
he's above the 70-year limit, right?
No, but that was used. There's no rule like that. That is all imagination of Mr. Modi, based on the suggestion of that Shakuni called Arun Jaitley. So there's nothing in the record.
So okay,
they have not. Nobody has spoken to me that I'm over 75. They may do it behind my back, but not in the front of me. So I think these are. Question is. Don't expect the judges. We select them. They amongst themselves select them, and then to expect them to be, pristine purity. I think it's too much expectation. You make incentives such that.
Look at this. What is it that makes judges look to these post-retirement benefits? It is because their salaries have been so pathetic when they're in service. There is hardly any country in the world which actually offers residential accommodation to sitting judges. That itself is an outrage. Instead, they're given such good salaries that they'll be able to afford decent accommodation, in which case there'll be no incentive to seek these post-retirement benefits.
These are all British concepts, which British imperialist concepts, which Britain itself doesn't have.
No.
Which we are continuing. I agree. You see. So that's the issue. Okay.
Venkat.
Yes.
As Hamlet said, or was it Shakespeare said, parting is such sweet sorrow. So,
Venkat, as you mentioned, the major litigants is the government.
Yeah.
What happens is.
That's a good point.
I feel if after perhaps like a writ petition, if the government loses at one level, they unnecessarily go up in appeal to various levels, even to the Supreme Court. So maybe
Jagdish, the rule is there in the government that you don't appeal after High Court. You see, but exceptions are allowed, and the exception is the rule now.
Yeah. So most of the backlog and cases most of them, large cases are all concerning government.
But there's another aspect to this, which I've personally experienced, which is public sector civil servants, the honest ones, and there are many of them. They are very willing to let the court process go and decide against the government than for them to
be accused
to accept defeat. So if they lose at one level, they'll still appeal, knowing full well that they're going to lose at the next level as well. But they would rather have a judicial order so that they're not accused of corruption.
Yeah, that's right. Well, all good things have to come to an end.
Okay.
Indeed.
So with this, on this note, we are ending today's program, and with this, that we are also ending the series, 21 series, Legal Gyan Ganga or Legal Words of Wisdom, Nyay Gyan Ganga. It was a great pleasure having Dr. Venkat Iyer take us every Saturday through this legal maze, and Dr. Swamy with his insight of as a public interest litigant and man who has been not a lawyer but who took to law arguing public cases, that it was a very interesting 21 series episode. So we thank Dr. Venkat Iyer and Dr. Swamy for enlightening our viewers on various legal aspects. And as I mentioned, we will be starting the economic words of wisdom, Artha Gyan Ganga, from next Saturday at 8 p.m. with Dr. Arvind Chaturvedi and Dr. Subramanian Swamy being on the show. I'm thinking our technical team, Ramesh, are they available?
Yeah, they're available. Once the show is over, you want me to bring them on now?
Yeah, I thought we'll introduce them to Venkat on the show.
Yeah.
So
they'll all join. Yeah, no problem.
Is Nataraj part of the team? No.
No.
Nataraj Shetty. He's coming up with a new book. Do you know about it, Jagdish?
No.
Okay,
Surprise.
I've asked them to join, Jagdish. I've just asked them to join. I've given them the link.
We'll be having another interesting thing, something to do with legal tomorrow. That is in our regular words of wisdom, the Sunday Gyan Ganga. That is, Sri Iyer has written a book on the National Herald scam.
Yeah, right.
So Dr. Swamy will be formally releasing the book, and National Herald scam revolves around the legal case, private complaint Dr. Swamy has filed in the Patiala House Court, and the case is now going on. So we will be having a discussion on this subject tomorrow at 8 p.m. Indian Standard Time on our regular words of wisdom. We have with us Tejas from Pune.
Who's Tejas? Yeah, his name is the right.
Hello.
We all know I'm talking for Venkat.
Yes, indeed. Yeah, and fortunately, it's at the center of the stage. I can see you very
Names
clearly.
are
Thank you very much for all your help.
Yes. We have Swaminathan from Chennai.
Yes.
He is there from Chennai. Then Gadgi Rakesh.
Alternative called Swami Lion.
Yeah.
Right.
Gadgi Rakesh from Karnataka.
Yeah.
A lawyer who has been very helpful as part of our team.
Very good.
have Ishwar Iyer from Navi Mumbai. Ishwar Iyer, just identify yourself. Ishwar Iyer from Navi Mumbai.
Yeah, I can actually see him. Hello.
Yes. Hi.
He's just below you. Yeah.
We don't have two people just now. That is Vishal Mehta and Ashish. They are not available to be online. So this has been our team. So we thank the team also for all their support to put the program together. And they help us in our Sunday program, and they'll help us in our next series starting program of next Saturday. So with this, it is thanking the entire team, Dr. Venkat Iyer, Dr. Swamy and Ramesh Swamy, for their useful 21 series episode which we had on legal words of wisdom.
Somebody called Jagdish Shetty also. Don't forget his name.
Indeed.
Without a doubt, Dr. Swamy.
Okay, thank you, and good night.
Good night.
Dhanyavad.
All right. Thank you.
Thank you.